Hello, everyone. Good morning, good afternoon to our friends and colleagues across the platform. Welcome back to our Labor and Employment Fall Virtual Series. My name is Eric Eisenman. I'm a partner here in our Milwaukee office and honored to currently serve as the practice group leader for our Labor and Employment Practice Group. We're glad to have attendees from across the U.S. to join us today as we cover our labor and employment updates for Illinois, Wisconsin, and for our first year, Michigan. Really excited about that. Before we begin, I do have a couple housekeeping items that I'd like to cover. At the bottom of your audience console, there are multiple application items that you can use for the presentation today. If you have questions during the webcast, you can submit those via the question box that's at the bottom of your screen. We do have attorneys standing by who will try to respond to questions as they come in during our presentation today that we will answer as time allows. We likely will not get to all of those questions during the presentation today. So if you don't get a chance to get one answered, we will follow up with you. A PDF of the presentation and other resources are going to be available in the resources folder at the bottom of your screen. This program has been approved for continuing legal education and HR education hours, and you can report your hours using the CEU icon on the bottom of your screen. A certificate of attendance, including the course numbers, will be emailed to you tomorrow, along with the recording of the webcast that you can share with others at your organization. Towards the end of our presentation today, we're going to ask for you to complete a short survey. We use that feedback from you to help plan further sessions that we're going to conduct in the future. So we really appreciate your feedback on our presentation today and also ideas that we might cover in future presentations. So that's it for the housekeeping items. I am now going to have us get started with our program. We actually have 6 separate sections of content for you today. About 3 from Wisconsin, 2 from Illinois, and 2 from Michigan. And as I said that out loud, I realized that that's 7, not 6. So let's say 7 sections of content. We're going to have some short breaks in between each of those sections in case you need to step away for a few minutes. Our first presentation today is going to be 2 of my colleagues here in Milwaukee. Jeff Trottier and Audrey Merkel are going to talk about the impact on employers of the new liberal majority on the Wisconsin Supreme Court. So excited to welcome Jeff and Audrey. Take it away, guys.
Good morning. Today we're talking about the changes we can expect from the liberal majority that we now have in the Wisconsin Supreme Court. And we'll be talking about other politically derived changes to the employment law generally. So as you can see on the screen here, in the election of 2023, most Wisconsinites know that we had a flip in the court. For the previous 15 years, we'd had a conservative majority, most recently made up of Chief Justice Ziegler, Justice Grassel-Bradley, Justice Rogensack, and Justice Hagedorn. With the 2023 election, that conservative majority became a minority, and we have a liberal majority with Justice Dallett, Justice Karofsky, Justice Walsh-Bradley, and the new Justice Janet Protasiewicz. So we're going to consider how that has changed or could change employment law in Wisconsin. Audrey?
Thanks, Jeff. Jumping in now to our first topic, which revolves around unemployment insurance. So there's currently a case pending in the Wisconsin Supreme Court, Catholic Charities Bureau versus the State of Wisconsin Labor and Industry Review Commission, also known as LIRC. And this case will impact when a nonprofit organization can receive the religious exemption for unemployment insurance. So just a quick reminder on the difference between nonprofits and religious organizations when it comes to receiving unemployment insurance, participating in the unemployment insurance fund, is that nonprofit organizations pay as they go into the fund, whereas religious organizations are completely exempt. So in this case, Catholic Charities argues that it should receive the religious exemption because their primary purpose is to fulfill the Catholic Church's goal of helping others in the community. Whereas LIRC then argues that the Catholic Church should not receive that exemption because they're providing social services to all residents of Wisconsin, regardless of faith. And some of those social services are offering low-income housing, providing assistance for the elderly, as well as providing disability services. The Court of Appeals found that the Catholic Charities was engaged in charitable activities, so the exemption did not apply. And what they explained in this case was that the charity's mission was not to evangelize or to teach people about the Catholic faith. They also did not participate in religious rituals or worship services with their clients. So for that reason, they said their primary purpose was not for religion, because they were providing just mostly secular activities to the community. The main question here will come down to whether the organization is operated primarily for religious purposes. So moving forward with this case, what we'll be looking at is if the religious purpose is defined in favor of Catholic Charities, how they define it as just providing these social services. And it does come down to if they do just have a general mission in favor of a particular religion, then this could really broaden this entire exemption. So we'll be looking at how this could impact not only religious colleges, but also hospitals as well moving forward. Again, just because if it does come down to having a mission that's rooted in religion, but the services can be as broad as helping anyone in the community, this can really stretch this religious exemption greatly.
So Audrey, I actually have a question about this. So it seems like this is a really fact-intensive kind of inquiry, isn't it?
Yeah, no, absolutely.
So really we would have to, or anyone trying to make this case would have to focus on this at what level? At the UI hearing level? Or will they have an opportunity once it would get into court to recreate that record?
I think it would happen at both levels. And I think it would really be rooted in what they're doing on a day-to-day basis and not just in their mission in general. So if it is rooted in religion, and then at each level, they will have the opportunity to then express how their day-to-day exercises or activities that they're providing to the community is to fulfill a certain religious purpose.
Okay, that helps. Okay, moving forward, the Rainbow Land school case coming out of Waukesha, Wisconsin. This is a new case that might not directly spring from the political changes that we've seen in the Wisconsin Supreme Court, but it has its roots in politics, specifically the Waukesha School District and School Board. It also involves First Amendment free speech issues, in this case, political speech. So in this case, the first graders in one Waukesha elementary school were all set to sing in their spring concert, and they were going to sing Rainbow Land by the great Dolly Parton and Miley Cyrus. And the district office and the principal had to vet this song choice. So they did, and the district associated rainbows in the Rainbow Land title with the LGBTQIA+ community, and therefore found the song objectionable under their controversial issues in the classroom policy, even though the policy was not always consistently applied. Previously, the district also found the Rainbow Connection by my favorite Kermit the Frog from the Muppet movie to violate their policies as well. They later backed down on this. As a result, after the first graders weren't allowed to sing Rainbow Land, their teacher posted on her private Twitter site, now X, stating that my first graders were so excited to sing Rainbow Land at our spring concert, but now they're not permitted to, and where does this end? And then she posted a screen grab of some fairly innocuous lyrics. So in this case, we're gonna try and figure out what are we gonna see from it. We probably will see a reliance on longstanding precedent that we have from the United States Supreme Court, saying that teachers and public employees don't have to leave their political opinions at the schoolyard gate. This comes back from wearing black armbands to protest the Vietnam War. So we may see this refined as a body of law as to what kind of content court will view as protectable. We also might see how the content or how the courts view different social media platforms. There was initially the question, is social media a private forum for speech? Is it a public forum, like going into a public square? Or is it a limited public forum, which is how they previously had found? Now this is a privately held account. Are they going to change that at all? So we'll keep an eye on that. Non-competition agreements, one of my favorite subjects. Non-competes in Wisconsin are notoriously difficult to enforce. And we've been aware for a while that non-competes are generally under attack across the country. The National Labor Relations Board General Counsel issued a rather unprompted letter to the board stating that she finds most non-competes, non-solicitation of customer agreements, non-disclosure agreements to be unenforceable and violating the National Labor Relations Act because it would impede free discussion of the workplace. Now let's remember, this is an advisory opinion, just a letter from the GC to the board. So while it doesn't have the force of law, it gives us a glimpse into how the board might rule. The Federal Trade Commission also has issued a proposed rule affecting non-competes prompted by one of the Biden administration's executive orders. And it would eliminate non-competes, finding that they violate antitrust law. There's a comment period and a revision period of this regulation that are fairly lengthy, so we don't have a final rule yet. We're getting towards a time period where we should have a final rule, but these things take a little time. So we might be at the end of this election cycle when we have that final rule. At that point, we might have a very different FTC. The executive order that rule is based on might be withdrawn because we could have a different administration. There could be new legislation that is introduced either at a state or federal level, which could affect non-competes, saying they are all prohibited or they are all permitted. All of this legislation probably, especially at a federal level, would be subject to constitutional challenge. So the point is, we will have to watch both the executive and judicial and legislative branches, so all three branches of government at both federal and state levels, to see where this is going. Audrey.
Moving on now to reproductive rights. So though a case isn't currently pending in the Wisconsin Supreme Court on this topic, it's thought that eventually the Wisconsin Supreme Court will be the final decision maker for this case. So the case is currently in the circuit court, and just this past July, the circuit court judge in Dane County ruled against a motion to dismiss, arguing that the abortion ban from 1849 did not apply to voluntary medical abortions. So technically, the law at issue here being challenged does not criminalize consensual medical abortions. Instead, the law provides that any person other than the mother who intentionally destroys the life of an unborn child is guilty of a Class H felony. So since the court has denied this motion to dismiss, Planned Parenthood, as well as other clinics in the state of Wisconsin, have resumed providing these abortion procedures for the first time since Roe v. Wade was overturned. So like I said, the decision will likely be challenged, so the Wisconsin Supreme Court will have an opportunity to hear this case. Depending on the decision, employers may need to provide additional specific benefits to its employees. So an example of this could potentially be providing paid time off for its employees moving forward if they want to receive reproductive care. Another aspect to consider are policies to have in place when it comes to attracting and maintaining your employees. So employees have been increasingly more clear that they want to work for employers who align with their values. And the best way for employers to, of course, demonstrate their values is through your policies. So some examples of policies to implement to show reproductive rights is a value would be providing PTO, as well as unpaid time off to attend marches or protests, as well as providing travel expense. The last thing to consider would be changes to your DE&I programs. And here are a couple of ways you could implement additional policies to show your support for reproductive rights would be increasing support within an employee assistance program for reproductive care, as well as providing resources to your employees when it comes to just getting additional information, as well as counseling and advice.
Audrey, I'm curious, have we seen any trends so far as to are employers offering these rights? Are they making changes to their DE&I program? Are we seeing trends that are state specific, or is it across the board nationally? What are we seeing?
Yeah, no, definitely more on a national level. Since the overturning of Roe v. Wade, we saw especially employers providing this travel expense reimbursement for the states that had the ban on abortion. So their employees, if they needed to or decided that they could travel across state lines. That's definitely the biggest trend that I saw standing out. But there is definitely like an increase in the trend towards changing your DE&I programs to provide not only time off. I'm not sure if it is always paid, but just definitely paid in terms of providing that reimbursement for travel is a trend.
So reimbursement for the actual travel expenditure, not necessarily paid time off.
Paid time off, right.
But the opportunity to exercise banked PTO?
Yes, exactly.
I see. Got it. Thank you. So Justice Janet Protasiewicz. We started off with the Wisconsin Supreme Court, and we're going to end with the Wisconsin Supreme Court in this discussion. Almost as soon as Justice Protasiewicz was elected back in the summer of 2023, there was commentary about possible impeachment of the justice. Now, we don't have a very strong history of justice impeachment in Wisconsin. There's only been one Supreme Court justice who ever was impeached, and that was, I believe, in 1853, and for some very specific statutory offenses. So it's a pretty high bar to reach impeachment. Nevertheless, if the justice was impeached, then Justice Protasiewicz would not be able to actually participate in decisions until there was a decision reached as to whether the underlying statutory violations that were alleged, whether she actually was convicted of those. So she would be essentially hobbled, sitting on the bench, but not participating. What happens then is, of course, we have this flipped majority that then no longer becomes a majority, but a parity. We would have a 3-3 split of those justices in the interim. So the court could still push through cases at that time, but a lot of the more partisan, politicized, hot button cases probably would just come to loggerheads and not actually have a decision. So more likely those cases would just be stalled. Maybe the court would reevaluate its docket and see what cases they would accelerate and decelerate. But in the meantime, Justice Protasiewicz would not be able to be involved. There are two lawsuits that we're trying to keep an eye on specifically because of this issue. There are two that are bringing challenges to Wisconsin's voter districting maps, which don't on their face affect employment laws, but they would affect the makeup of Wisconsin's legislature, the people who make the laws and pass the laws. And therefore that would then not have so much of a trickle down, but a pretty substantial effect as to what employment laws would be passed and how that would shape our laws going forward. Now, at this point, no impeachment papers have been submitted. It's more prognostication in the press as to whether this will happen. So it seems like it's going on a rather slow roll, another thing that we'll keep an eye on. And with that, I guess we'll go back to Eric.
Thank you, Jeff. Thank you, Audrey. I feel like that presentation gave our listeners a good overview of why we like that.
Change. There's always drama. It's always interesting. I feel like our clients sometimes get frustrated about how the pendulum sometimes swings, the law changes in this area. But as I said, a good overview, I think, of a lot of those interesting topics that we get to deal with on a regular basis. One other thing I'll mention before I hop into this poll question that will warm us up for our next session here. One of the things that Jeff and Audrey talked about as an area which could be subject to change as a result of the new majority on the Supreme Court is that topic of DE&I. to the extent that you've been part of some prior presentations that our practice has provided, we've talked a lot about what impact there may be on corporate diversity, equity, and inclusion programs as a result of a lot of the different things that have happened recently, both in Washington and in Madison. You know, the Cliff Notes version that I'll give you here is our advice to employers is that those sort of DE&I programs remain lawful. There are legal challenges to some of those programs that are focusing exclusively as race as a deciding factor. So much more to come on that, but something is just an overview for you to be aware of, and something that we are obviously happy to assist with to the extent that you have more questions on that topic. As I said, we're going to move into a new topic now that's going to hit on concepts of artificial intelligence and how that impacts the workforce. But before we do, we wanted to do this poll question to sort of do a little bit of benchmarking for those of you who are on the call. So the poll question is, has your business made decisions about hiring or expansion based on the employment laws of a specific state? This is not actually the poll question that I thought I was going to answer, but this will also still be very interesting for us. We're covering 3 different states today. We're covering Wisconsin, Illinois, and Michigan. And so as we set the table here, the question is going to be, have you made a decision about hiring or expanding because of the laws of a particular state? We're going to be talking about how some of those laws are different. Some of them are more worker friendly. Some of them are more business friendly. So I'm interested in seeing what you all answer here. Yes, I've made this, my business has made the decision. No, but we might. Or C, we wouldn't make a decision based on the laws of the state. So go ahead and select A, B, and C. We'll wait a moment to let these sort of responses come in. One of the reasons this comes to mind recently is we've seen a lot of activity in southern Wisconsin, for instance, about businesses who may have historically been located in Illinois that are electing to expand or develop, opportunities in Wisconsin because of what they perceive as potentially a more employer-friendly legal threshold or tax framework. Let's go ahead and see these responses, please. All right, so it looks like an interesting sort of mix here. We've got about a third of our participants who have said that their business has made decisions based on the laws of a specific state. Another substantial chunk that would suggest that they might do that in the future. And then finally, a meaningful percentage here that said that's not really going to impact it. But my takeaway there is we're looking at, almost 70% of employers saying the laws of that state are going to impact sort of my decisions. So something to take into consideration. So as I said, that poll question was not about AI, but our next presentation is. I'm excited to introduce 2 of my colleagues here in Milwaukee, Laura Malyagade and Caitlin Doyle, who are going to talk a bit about the impact of and potential impact of artificial intelligence in the workplace. Laura and Caitlin, take it away.
Thanks, Eric. My name is Laura Malyagade. I'm a partner here in our Milwaukee office, practicing exclusively labor and employment law, and I'm here with Caitlin Doyle to talk about a topic that I think we have all been inundated with recently, and that's artificial intelligence in the workplace. This is something that we all know we need to get on top of. We all know the topic is not going away, it's only increasing, but it can be a bit daunting, especially for those of us in the HR space who are admittedly perhaps not the most tech savvy. You may have heard the phrase, AI is not going to take your job, but people who use AI, it will. I think that is a pretty apt way to describe it, and it is showing that there's a real big reason why we all should educate ourselves on this topic, because it is certainly not something that is going away anytime soon. So when it comes to various legal considerations related to AI in the workplace, there are a million things we could talk about. But today we're going to talk about bias and discrimination, data security, some considerations under the National Labor Relations Act, as well as state and local regulations, and some tips and suggestions to keep in mind for mitigating the risks as we face this new frontier. So speaking of the new frontier, the EEOC, you'll see on here, has been referring to AI discrimination as the new civil rights frontier. And earlier this year, the EEOC actually held about a 4-hour hearing where they listened to testimony from witnesses from kind of all over the spectrum related to AI in the workplace. a lot from the employee rights side, a few from the employer's perspective. And it was really a fascinating discussion that was centered on how can we make sure that these machines are making unbiased decisions. And, you know, there's no question, you'll see today in our discussion, that AI can replicate existing biases. But it's also been shown to help increase the diversity of our applicant pools and be very effective in helping reduce that unconscious human bias that can be so hard and difficult to root out. So to date, the EEOC has released some guidance, both on the Title VII and the ADA front, and they've made it pretty crystal clear that employers can be liable for discrimination that results from the use of AI in the workplace. It's also clear that employers can be on the hook for decisions that are made by AI vendors that they use, even if they're not involved in actual algorithm development or things of that nature. So ultimately, you know, AI made me do it is not going to be a defense in the long run. So what does this look like? How can employers actually be liable for things like gender, age, race, disability discrimination through things like the use of AI in the workplace? Well, some examples here on the screen. One is a gender discrimination example. You might have heard several years ago, Amazon was developing a program internally to vet applicants, and they were building an AI recruiting tool, and the data input that they used was about 10 years worth of historical applicant data to, you know, software developer positions and other tech positions to determine, okay, what is an ideal candidate? Well, I don't think it's going to be a surprise to anyone here that the tech industry has historically been pretty male dominated. And so the AI tool essentially taught itself that men were preferable candidates over women and would reject the female candidates. So thankfully, Amazon had human oversight over that tool. And when they realized that's what was happening, they did away with that program. But there are lots of other examples on how this can come out too. So for example, if there's chatbots or different things that may be analyzing resumes. Someone, you know, it may determine, well, there's an employment gap here and in their resume, and that suggests, you know, maybe not as preferable of a candidate. Well, that could be for all sorts of reasons, as you can imagine. Maybe someone was taking time off to take care of children. Maybe they had cancer treatment. And, you know, those are things that we need to be careful that are not being screened out for those reasons. Another example on the race discrimination front is that there's concern about the software learning that perhaps individuals from a particular zip code are not as preferable candidates as from other ones. And, you know, we all know sometimes zip codes can reflect fairly homogeneous populations, which then in turn can exclude certain, you know, races or even religions from consideration. There are interviewing tools out there that may analyze speech patterns, for example, or eye contact, which of course could become problematic if someone has a stutter and the program is saying this person isn't suited for this position, or if someone's eye contact isn't appropriate and perhaps it's not a job-related requirement. Maybe they're working in a tech field where they're just dealing with a computer all day. So there are lots of different ways that this can become an issue if it's not done correctly and properly validated. You also see on the screen the EEOC recently settled its first ever AI bias in hiring lawsuit. So in this case, there was a tutoring company who was using an AI software to source and screen candidates, and an applicant submitted an application and put his or her actual birth date, which put them, I think, 6 years or older, and they were rejected. Well, that person decided to submit the exact same application with a birth date reflecting a younger age, and the person was accepted. And so that case, I believe, settled for, you know, $400,000 or something of that nature. So as you can see, even though AI in the legal sphere is a new concept theoretically, the underlying legal issues here we're dealing with are not new. You are all familiar with these just in different concepts. So we know the steps that employers need to take to start thinking through the issues and the concerns associated with it.
That's a great summary on how AI can be problematic using outputs, but AI can also be problematic using inputs. So to kind of take this back to an internal sourcing, data security, confidentiality in trade secrets is not a new issue, but it's something that is implicated with the use of AI. So for instance, think about an instance where you would be using AI like ChatGPT to help you write a grant proposal. Some of that information that you might put in could be confidential, such as, the pricings or university numbers, if those are necessary for the grant. And if you put those into ChatGPT, it might give you a really good grant application. But now that data is at risk of no longer being confidential. You can see on the slide here that we've just pulled some terms and services from ChatGPT itself. And you can see that it expressly admits that it uses and collects personal information or inputs in order to help train their program, as well as alerts you that they might release it to third parties or vendors or pursuant to legal requirements. So anything that you put into ChatGPT and similarly other AI sources, is now on the open web, and that's problematic from a confidentiality and trade secret perspective. And even if you are not doing it, there's a lot of research to show that your employees might be using ChatGPT to help kind of streamline their work. There have been reports of individuals using it to write blogs or articles or draft emails. And these things might be great for that employee. It probably does help them do it efficiently. But if they're not aware of what they can and cannot put into these systems, your company is going to be on the hook for that at a later date, or could be on the hook for that at a later date. So we definitely recommend, if you are using AI or you think your employees might be using AI, that you should have some data protection policies associated with that, so that employees are at least on notice of what they can and can't do with AI, such as ChatGPT. And if your company does support the use of AI, well, what are the restrictions on that? What are the ramifications of misuse? You need to really be thinking about the long-term impacts of using AI and how that could potentially impact what is confidential down the road if you're trying to enforce that confidentiality at a later date. Now we're going to move into the National Labor Relations Act. So we've kind of talked about how AI is problematic, or can be problematic with inputs and outputs, but it can also be problematic to even implement in the first place. One of the things that we've been seeing in the news recently is this WGA and SAG-AFTRA strike. A big part of that is this use of AI in those industries. And so, you might be thinking, well, that's a future concern. We're not going to pay attention to that. It definitely could be. So if you do have a unionized workforce, with just how broadly AI is, the definition, it could be anything from ChatGPT to fully automated work systems. How you're implementing that and what it's doing could definitely be a problem for a unionized workforce. So think of an instance where you're implementing AI and that AI implementation touches a term and condition of your employees' terms and conditions of employment. Well, now all of a sudden you have a mandatory or a possible mandatory negotiating subject that you have to negotiate with the unions before you can implement. And if you don't, you're going to get in quite a bit of trouble if it is determined that it was a mandatory bargaining provision. So before you decide to implement any sort of AI, you really have to do a deep dive into the consequences, intended and unintended, how you're going to implement it, how it's going to be utilized on a day-to-day basis, to really determine if this is something that the union has to be a part of in the decision-making process. Similarly, even if you don't have a unionized workforce, if you do decide to implement AI, that could lead to bargaining or to a move for unionization within your employees. And the National Labor Relations Board has actually come out with guidance to suggest that even threatening an employee that they're replaceable by AI could actually chill, to use their words, the Section 7 rights of an employee, and could be an unfair labor practice, even in an ununionized workforce. So I don't want to scare you. Is that possible? Sure. a lot of things are possible. Is it likely? That just depends on the situation and the case and who it comes before. So I think it's going to be really interesting to see how this SAG-AFTRA and WGA negotiations resolve and what is put into those contracts based on AI. But you should be aware that other unions are looking at this strike and are probably going to take a lot of the same approaches or requests moving forward as applicable in your own negotiations.
That's right. I think that's a really important thing to flag for everyone. We all know the NLRB is doing some quite interesting things these days, to put it one way. So another thing to be on the lookout and be aware of are the increasing state and local regulations regarding AI in the workplace. There is a fair amount of pending legislation and some that has been passed already. I've got 2 examples here that have been kind of at the forefront of discussions. There's the Illinois Artificial Intelligence Video Interview Act, and then New York City recently implemented a law as well that governs employment related decisions that are made in the hiring and promotion process for using AI. So the Illinois law has been around, I think, a couple years, maybe since 2019. But the concept here is that if employers are using AI in connection with video interviews, they actually have to inform applicants about that and get their consent to move forward with that interview process. And the theory here is that applicants may need a reasonable accommodation through your process. And the legislators are saying, well, how are they going to know if they need an accommodation if they don't know that you're using AI in this process, or if they don't know what is actually being considered in this process? So you actually have to not only tell them you're using it, but how it's being used, which is, an important thing to remember. There's also document retention and destruction requirements as well. New York City has taken it even further, and this is a pretty strict law with a requirement that you also have to do an annual independent bias audit conducted by a third party, and you have to publish those results on your website. So that raises a lot of questions as to what does this bias audit look like? What are the requirements going to be? I think there's a lot of unanswered questions, but I will say that this is, something that employers have been dealing with for a very long time in different formats in terms of selection criteria for applicants. So doing multiple choice tests or things of that nature. There's uniform selection criteria that have been around from the government since the 1970s. And there are industrial and organizational psychologists who have been working on specifically this issue of analyzing, your interviewing and hiring process in light of the job skills and responsibilities to ensure that you're not making an adverse impact on a particular group. So this is something that there will absolutely be more to come and a lot more to learn here, but it's something we should all be paying attention to. So in terms of mitigating risk, we've talked about most of this or a good amount of this already, but it really is important to develop a policy that is designed to protect your confidential information of your company and make sure your employees know the expectations. And then we can enforce that if employees are not following those expectations. Training is also really important. We need to understand how this works, what it's doing, what are the potential biases, and how can we help get rid of them. And in order to do, and then use that training to conduct audits of our system, we need to have human oversight over these systems. And if you're using a third-party vendor, you need to do your due diligence on that vendor and find out how that process is working. It's really, really important. And of course, staying on top of the legal developments, this is going to just be an issue that's going to skyrocket, I am confident. So stay tuned, more to come. Thanks so much.
Thanks, Laura. Thanks,
Caitlin, a fascinating area, sci-fi come to life. It's something, as Laura mentioned and Caitlin mentioned, that your employees are talking about. And I really liked that they both emphasized the importance of messaging this to employees, right? I mean, it is inevitable that this is a technology that is going to impact the workforce. But the key here is talking, and I liked the way that Laura started out. AI is not going to replace your job, but it may replace you if you're unwilling to learn how the technology works. So a lot of interesting legal issues that relate to that. I promised you poll questions regarding AI, and I'm going to give you 2 of them now. Here's the first of the 2 poll questions. Has your organization implemented a policy that governs the use of AI in the workplace? Let me assure you, this is completely confidential and anonymous. We find that these sort of questions are often helpful for our participants to do a little bit of benchmarking. So I'd encourage you to answer this. Has your organization implemented a policy that governs the use of AI? Yes, no, or I don't know if we have or not. Give you a moment to sort of select these, and then we'll go to the results. I can tell you that our law firm, for instance, has been spending a lot of time and resources on thinking about the ways that AI might interact with our job. And we've got a pilot project going on right now where we're going to have groups of associates who are using AI for particular tasks and others who are using traditional sources, and basically evaluating the outcome of those projects to see how that impacts and what risks might be. So let's see the results on this first poll. Who is using a policy? The vast majority of you don't have a policy. I suppose that should make you probably feel okay if you don't have a policy, because it looks like this is very new for a lot of us. The majority of companies don't have a policy. I think that if we asked the same question in 12 or 18 months, we would see pretty significantly different results, because we're on the cusp, I think, of AI really impacting the way that we do business. Let's go to that next poll question. This one, I believe, is specifically about ChatGPT. Have you used ChatGPT or other forms of generative AI for work-related purposes? I think I'm most interested in sort of you specifically, the person who's watching this presentation. Have you used ChatGPT for anything related to your work? I will make a full confession. I have played around with ChatGPT when we're asked to sort of, draft letters, template documents. None of those have been billable to the clients, and none of those have involved confidential information. But it's interesting to see the way in which a lot of the writing tasks that we've historically done might be enhanced or assessed with ChatGPT. So let's see the results here. Who has used ChatGPT or that sort of generative AI for work-related purposes? The vast majority of no. Okay, so a very small percentage of you are either brave enough to try it or willing to admit. And most of you who have tried it have done it, I think, to some extent. But again, I think that, again, in 12 or 18 months, these results will look very different. Okay, on from AI to our final Wisconsin-related topic. Excited to welcome my 2 colleagues here in Milwaukee, Scott LeBlanc and Eric Locker, who are going to be addressing some recent developments in Wisconsin's disability accommodations law. Scott and Eric, the floor is yours.
Well, thanks, Eric. Good morning. I'm Scott LeBlanc. I'm a partner here in our Milwaukee office, and I'm extremely excited to introduce Eric Locker, who is the newest member of our team. Eric, thanks for joining us today.
It's great to be here.
And so, Eric, one of my favorite things about being an employment lawyer is no matter if it's your first week on the job or if you've been doing this for a long time, you're constantly always having to learn new things because the law is always changing, or we're getting new cases that are coming down that are sort of bringing clarity to areas of the law where we didn't necessarily know what the answer would be before. So that's what we're talking about today. We're going to take a brief peek at 2 cases, one under federal law and one under Wisconsin state law, that provide a little bit of additional clarity on some areas relating to disability accommodations under federal and state disability law, and just talking about what the details of those cases were and sort of what takeaways we can take from those cases going forward that help inform some of our decision making. So first, a reminder, if you are a Wisconsin employer, most Wisconsin employers are subject to both federal and state disability discrimination law. Now, in many states, that's not necessarily an issue, either because there isn't a separate state law, or the federal law and the state law are so similar that you don't really have to worry about different standards. By and large, that's mostly the case in Wisconsin, although Wisconsin law does differ in one specifically important way, and that is, as you can see, how it defines disability. Many of you know that under the ADA, the standard is that a disability is a physical or mental impairment that substantially limits a major life activity. In Wisconsin, that standard is a little bit looser. It only requires an impairment that makes achievement unusually difficult or limits the capacity to work. So in some cases, you'll see cases under Wisconsin law that are going to come out with maybe a slightly different result than what we would see under the ADA. And we always have to be mindful of that as Wisconsin employers, that we have what might be considered to be an enhanced obligation with respect to disability accommodation that you might have in other states. So as most of you know, disability discrimination laws require a duty to accommodate. By accommodate, that requires a reasonable accommodation, that employers make certain changes to the work environment that enables an individual with a disability to enjoy equal employment opportunities. So these accommodations often take the form of time off, changes in schedule, providing an individual with a seat or some sort of way that they're able to do their work appropriately. There are two other kinds of accommodations that we see under Wisconsin law that don't necessarily arise under the ADA. One is job restructuring of what are non-essential functions of the job. So there is a case that goes back about a decade or so that says that if there are certain non-essential functions of somebody's job, you may actually be required to take those duties and give them to somebody else as an accommodation. The other form of accommodation that we see in Wisconsin is what's sometimes referred to as clemency and forbearance. So what that means is, particularly with respect to attendance policies, if there's an individual with a disability that keeps them from being able to comply with what would otherwise be generally applicable policies and procedures of the company, that the company might be required to excuse some of those violations of company policy, at least in the short term, in order to accommodate somebody's disability, enable them to be able to perform the job over time. Both federal and Wisconsin law, once a request for a disability has been made, we then go into something that we call the interactive process, which is a process by which the employer and the employee sort of go back and forth, discussing the condition and the limitations that it imposes, and trying to identify what, if any, accommodations might be appropriate that would allow that person to be able to perform their job. Under both federal and Wisconsin law, an employer has the right to be able to request sufficient medical documentation in order to be able to determine the nature, severity, and the duration of the impairment. How long is this accommodation going to be required? What is actually required? Because remember, employers are not necessarily required to provide an employee the accommodation of their choice, only an accommodation that allows the employee to be able to perform that job. And if an employee's documentation is insufficient, the employer may then follow up and require the employee to go to a healthcare provider of the employer's choice on the employer's dime. So with that background, I want to talk a little bit about the recent case, which is Winagra Ready Mix versus Lurk. This is a Wisconsin case, so it's interpreting the Wisconsin Fair Employment Act. And in this particular situation, Wingra is a company that delivers concrete, I imagine, to construction sites. And the employee in this particular case is a truck driver. Now, this truck driver had been driving a truck for a while and all of a sudden started to get some back pain, some leg pain. And they requested that the employer allow them to drive one of the newer trucks. The interesting thing about this case is this particular company had two kinds of trucks. It had older trucks, which did not have shock absorbers and were apparently a very rough ride. And they had some of these newer trucks that had shock absorbers on them and were supposed to be a little bit easier on the body. There were only a few of the newer trucks, most of the older trucks. So obviously everybody wanted to drive the nice new trucks. And this person had made the request to be able to drive a new truck because thought it would be easier on their back condition. Wingra, the employer in this case, had a policy against switching trucks. This person had been assigned to one of the older trucks, and they said they have no evidence to deviate from their policy. They denied the request of the employee to move to a newer truck. The driver quit and then was later diagnosed with some severe physical impairments that were present while they were employed. So the legal question in this, obviously the employee then sued for disability discrimination. And the question is whether or not a medical documentation is required in order for an employer to know of an employee's disability. So in this particular case, the company had taken the position that it's the employee's duty when they're requesting an accommodation to provide the medical documentation that convinces the employer that this accommodation is required. So the outcome of this case is that we have a very clear direction now from the court that under Wisconsin law, and I would argue probably under federal law as well, medical evidence of a disability alongside an accommodation request is not required. All an employee has to do in order to start that interactive process is to put their employer on notice that they have a medical condition that might constitute a disability. Now, if the employer wants to request more information from the employee in order to determine what kind of accommodations might be appropriate or whether or not the condition rises to the level of disability in the first place, that's okay. But the employer can't sit on their hands and wait and say the employee is the one that has that obligation in order to be able to prove it. This case also had sort of an interesting wrinkle to it in the sense that the employer was very tied up in the question of whether or not the employee was diagnosed with a particular problem. And the court was very clear that a diagnosis in and of itself is not a requirement in order to trigger accommodation requirements under state law. So what that means is that if an employee has back pain, you don't necessarily need to know what it is that's causing that back pain at the time in order to trigger that accommodation requirement, only that the effects of that pain are existing and making an employee's ability to perform their job difficult. Practically speaking, our suggestion is you have to ask yourself, would a reasonable employer have known that the employee is asking for an accommodation? If you have to question whether or not there is a disability, it's safer to assume that there is until you have medical documentation that's telling you otherwise. So again, employers still retain the right to be able to request documentation from their employees, but if you don't ask for that documentation, you're pretty much left in the position where you're basically assuming that the employee has a disability and you have the obligation to accommodate there. Now, the exception to the obligation to accommodate is the undue hardship standard, which is found under both federal and state law. And that requires the employee to reasonably accommodate unless the accommodation that's been identified or there is no other alternative accommodation that's available that would not pose an undue hardship on the business. So for example, in our concrete truck case, if all of the trucks that the employer had were these old trucks without shock absorbers, and trucks are extremely expensive, and this is a small company, then perhaps the company could say, well, it would be an undue hardship to require us to go out and buy one of these fancy new trucks because we just simply don't have the budget to be able to do that. I'm not saying that necessarily would win the day, but that's how the undue hardship standard works, which is you look at the size of the company and its resources to determine whether or not the accommodation that's being requested is appropriate. So now I'm going to toss it to Eric to talk a little bit about the federal law case involving commute accommodations, which is also kind of an interesting question.
Yeah, so commuting accommodations are a new accommodation that's been kind of upticking among requests by employees. And there is a circuit split, which for the non-lawyers here, all that matters is that means the courts disagree. It means the law in one state might not be the law in the other. And importantly for us here, in the Seventh Circuit, they say a commuting accommodation, so such as an altered schedule, alternating flexibility of your schedule, that yes, that may need to be accommodated. And the Seventh Circuit, that covers Illinois, Indiana, Wisconsin. Whereas in Michigan, they say, no, you don't have to accommodate those commutes because it exists outside the workplace. And it's just not the employer's duty. Now, Michigan folks, that does not mean you get to sit back and not listen to this case, because what the trend that we're seeing is these circuits switching, and courts are saying, actually, no, I think the accommodation for commuting is part of the workplace. They're saying when physical presence is required, it's an accommodation that could be reasonable. So now we're going to look at the EEOC versus Charter Communications. This was a very recent ruling, and I'll walk you through the facts of that case a little bit. So this case involved a call center employee who worked at Charter, and he was, a call center employee. He made phone calls, and he had cataracts, which made it trouble getting to and from work when it was dark. His schedule was from 12 p.m. to 9 p.m. So during the day, he was absolutely fine, but that 9 p.m. made his drive always in the dark. He requested an adjusted work schedule, which Charter initially granted for 30 days. They moved it from 10 a.m. to 7 p.m. He was working the same amount of hours, and it was during the summer, so he was able to get back home with a reasonable amount of light, and he didn't have nearly as many issues. He then requested a second extension so that he could find a place closer to his place of employment. He lived an hour away, so it was getting a little bit hard to avoid the darkness. Charter denied that extension, which is when the call center employee filed suit and claimed failure to accommodate, which presents our central issue, which is whether an employee with a disability can be entitled to a work schedule accommodation to allow him to commute more safely. And so the court really framed this as a commuting accommodation, changing, it doesn't seem like it's commuting related, but it's changing a schedule to accommodate the ease with which an employee can get to work. So there is, what the Seventh Circuit said was there is no bright line rule. They weren't gonna say for sure we always have to accommodate or you never have to accommodate. And that's just by virtue of how the ADA really works. It's all very fact specific. And so it's not surprising they said there's no bright line rule. What they did say is that commuting accommodations may be required, and it just depends on the individual job and the individual employee. But the key part was that physical presence in the workplace has to be an essential function, which in this post-COVID world we're in now, that's kind of a big question with a lot of these places. You know, a call center, perhaps they could perform this work at home. Maybe it wasn't necessary for him to be at the call center itself. And so it's one of those things, it's a very highly fact-specific inquiry. And when you're presented issues like this, it's still best to reach out to legal counsel, as it always has been. And like we said, the determination, it's still based on, is it reasonable and does it cause an undue hardship? It may be impossible for the employer to switch and do, there's not enough employees to cover that shift time. We still have to make that analysis. There's still a lot of variables to consider.
Yeah, and that's really interesting too, right? Because Charter Communications is a large company with a lot of resources, right? And that in and of itself speaks to the question of whether or not it's an undue hardship. If they have employees that are working at home or they have employees that are working on different schedules, that those facts may work against them as part of that undue hardship analysis, which is always really interesting. So I think bottom line, there is no one size fits all, right? Eric mentioned it in the Charter Communications case. You know, accommodations are a case by case. They're very fact specific. They depend on the employee. They depend on the accommodation the employee is asking for. They depend on the company and its resources. Second, there are no magic words that trigger that interactive process. Don't expect that your employees are going to know exactly what it is that's causing their problems, and they don't have to necessarily know at the time in order to trigger the requirements to enter into the interactive process. Still, don't be afraid to ask for documentation. That is okay. And that documentation could open up other alternatives that are more reasonable accommodations, at least from the employer's perspective. And no workers are interminable. You know, I always caution our clients, you want to be as patient as possible. Err on the side of patience when you have an employee that's asking for accommodations at first. But there are ways to get out of it. And it's better to nip those things in the bud sooner rather than later. You don't want to have a situation where an employee has been doing this accommodation for years and years. It makes it that much more difficult to then stop the accommodation. So you really want to be proactive in dealing with these things and getting the documentation that you need in order to be able to put in place a solution that works for everybody.
Thank you, Scott. Thank you, Eric. Really appreciate that excellent overview. As Scott said, this is Eric's like 6th or 7th day as an official member of the Husch Blackwell team. So wanted to extend special thanks for him for participating and contributing today. I could feel the collective anxiety and blood pressure of our clients rising over the course of that presentation as we say things like, there's no bright line rule, it's a fact-specific analysis, the law is changing. We fully recognize and empathize with you as business owners, HR professionals, people making decisions, that disability discrimination context is incredibly difficult. And on top of it, as our last presenters just hit there, you are forced to essentially look at a framework which is, one legal standard under federal law and a separate one depending on which state you're located. But I think that was a helpful overview. I thought those were some really excellent takeaways at the end about the importance of having patience, right? I feel like our experience has been that if you are willing to go through that interactive process, it doesn't guarantee a perfect outcome. It doesn't guarantee that you're not going to, receive a claim, but it's going to put you in a much stronger legal position. So appreciate that overview. That concludes our Wisconsin portion of the presentation. We're hopping on the Amtrak Hiawatha and heading about 100 miles to the south to Illinois. It's probably good that we're having this group presentation now and not in a couple weeks, as the Brewers and the Cubs are battling for the National League Central crown, potentially a playoff series. But I can tell you right now that I am very excited to welcome our Illinois colleagues, two of whom are going to get us started today in some discussions about recent changes to Illinois wage and hour laws, Julie Garabedian and Jennifer Ralph. Julie and Jennifer, take it away.
Thank you, Eric. As Eric said, my name is Jennifer Ralph. I'm an attorney in Husch Blackwell's Chicago office, and I'll let my colleague introduce herself as well.
Thank you, Jen. My name is Julie Garabedian. I am also an attorney in Chicago's Husch Blackwell office.
We're going to be talking to you today briefly about recent changes and upcoming changes to Illinois' wage and hour laws. So we'll focus on two main laws. The first is amendments to the Illinois Day and Temporary Labor Services Act, and then Julie will give you an overview of the new Paid Leave for All Act. So let's start with the Day and Temporary Labor Services Act. Effective August 4th, we have 4 major changes to that law. First, temporary workers, so these are employees of staffing agencies, are going to be required to be paid the same pay rate and benefits as comparative employees at their client site. Second, the law is now imposing obligations on both staffing agencies and their clients related to health and safety in the workplace. Third, there is a new obligation on staffing agencies to provide notice to their employees under certain circumstances when labor trouble exists at a work site. And finally, there's increased penalties under the Act. So let's start with the first major change. Now, again, this is already effective under the law. Staffing agencies are going to be required to pay their employees the same pay rate and equivalent benefits as comparative employees at their client site. So what is a comparative employee? Under the Act, that's an employee, a directly hired employee at the client site that has the same level of seniority and substantially similar job duties under similar working conditions as that temporary employee. What are equivalent benefits? That's a great question, and it's not defined in the Act. However, what the Act does tell you is that the staffing agency can pay employees the cash hourly equivalent of whatever those equivalent benefits are. Now, how is this going to work in practice? The Act requires clients to work with their staffing agencies to make this happen. So in practice, likely the staffing agency is going to be making a request to the client, and the client is going to be obligated to provide information to the staffing agency to allow for compliance. So essentially, it's just going to be a collaborative process to aid in compliance. Let's talk about the second major changes to the Act, and that relates to health and safety practices. And as I mentioned earlier, the Act is now going to impose compliance obligations on both staffing agencies and their clients. So staffing agencies, what do they need to do? There's a number of things under the Act, but in short, they need to look at where their employees are going to be placed and what hazards they might be facing in the work site and provide them training related to safety and facing those hazards. They're also going to be required to provide training to their employees on how to report to the Department of Labor about any concerns they have about safety in the workplace. Likewise, clients are going to be required to look at their work sites and provide temporary workers with training specific to any hazards they might face in the work site they're being placed in. Now, let's talk about the third major change to this law, and that relates to labor disputes. I think we've all been seeing in the news an uptick in discussions of labor disputes, and this law is addressing that. So when staffing agencies are going to be placing a worker at a work site that has a labor dispute, so that might be a strike, it might be a lockout, it might be any other type of labor trouble at the work site, they're going to need to provide that employee with a written notice that tells them, one, they have a right to refuse that assignment, and two, that that refusal is not going to be with prejudice to them receiving another assignment. And finally, everyone's favorite, there's going to be increased penalties under the Act. So first, previously under the Act, aggrieved employees or the Illinois Department of Labor could bring lawsuits under this Act. Now there's a new class of organizations that can sue under the Act. So this is defined as any interested party can sue. What is an interested party? Well, you can see it there on the screen. It's an organization that monitors or is attentive to compliance with public or worker safety laws, wage and hour requirements, or other statutory requirements. There's also newly increased penalties under the Act. So for the first violation of the Act, an employer or an organization that is not in compliance with the Act can face a penalty of anywhere from $100 to $18,000. For any repeat violations, those penalties are $250 to $7,500. Don't ask me how they came up with those numbers. Something to keep in mind for those penalties is that they can add up, because a penalty might be for every single worker and it might be for every single violation. And finally, now under the Act, client companies may face a penalty for working with a staffing agency that is not properly accredited under the Act. So within that in mind, this is a new Act that everyone is figuring out compliance with, and we're always happy to assist with those questions. And I'll turn it over to Julie to talk to you about the Illinois Paid Leave for All Workers Act.
Perfect. Thank you, Jen. So I am going to start coverage on the Illinois Paid Leave for All Workers Act. One thing to note is that this act is not yet effective and will be in effect on January 1st of 2024. So you have plenty of time to get your handbooks and policies ready by then. So first, who is this going to apply to? So notably, this is going to apply to any individual permitted to work by an employer in any occupation. Think your part-time employees, your full-time employees. This is going to include exempt employees, but it is going to exclude independent contractors. Two also notable parts about the Act is that this is going to apply to employees based out of Illinois, but that are physically present in Illinois performing at least 40 hours of work in the state yearly. So as of this morning, there are no Department of Illinois regulations that have been issued yet. So it is still unclear in the Act whether it's going to apply to employees working remotely outside of Illinois, but for an Illinois-based employer. So stay tuned. As you can see, there are a handful of exceptions to this. Some of the exceptions, as you can see, we've outlined here. You're gonna have your railroad employees, your temporary college or university student employees, or you're going to have the short-term employees of an institution of higher learning, and you can see the rest of the requirements there that are only with the employer for a very short amount of time with no expectation of return. And then we're going to see employees in the construction industry and who are covered by a bona fide collective bargaining agreement. And lastly, employees who are covered again by a bona fide collective bargaining agreement, but that are specifically providing services of delivery, pickup, and transportation. Okay, let's get into the leave details. Now you're gonna have two options moving forward here. You can either set the leave at an accrual of 1 hour for every 40 hours worked, and this is going to be for a minimum of up to 40 hours. Of course, you can have more, but the minimum is 40. Or you may front load this time. So that means you're going to front load the full 40 hours at the beginning of the time period. You're probably wondering, what about my exempt employees? How much are they deemed to have worked? So exempt employees will be deemed to work 40 hours in a work week unless their regular work week is less than 40 hours. So in which case the accrual is going to be based on that regular work week, but it's not going to be anything outside of the regular accrual rate already provided for in the Act. Something else that is very important to note is that the employees can take this leave for any reason of their choosing. They don't have to say one versus the other or get permission otherwise. And employers cannot require documentation or certification regarding the time off. What you can do is implement a reasonable notice policy. So something like that would be a 7 calendar day notice if foreseeable, but if the leave is not going to be foreseeable, the employee just needs to provide as much notice as practicable. Here's some more important details from the Act that we didn't want to leave out of this presentation. You can set that reasonable minimum time increment. So in the Act, that's going to be 2 hours a day. You can't take any less than 2 hours a day off. So you can't set something like 4 hours. You may have that in your policy right now. You can define the 12-month period, so you can make this a calendar year, or you can make this at the date the employee starts. We see how that can get confusing, so we recommend that you do have a consistent policy on this. Something else to note is that this leave can be banked separately from other sick leave or PTO. So if it is banked separately, the employee does get to choose the bank of leave that they get to pull from. And if it's banked separately, the leave does not need to be paid out at the employee's separation. So that's something to keep in mind when you're considering whether or not you want to bank this paid leave for all workers separately or not. Unused time must be reinstated to employees who are rehired within a 12-month time period of separation and made available for immediate use to them. Something that you cannot do is that you cannot require an employee to search or find coverage as a condition of providing this leave. So now we're going to get into eligibility. So employers are going to be eligible either on 90 days following the first day of their employment, if this is after the new year, of course, or 90 days after the Act is in effect. And don't worry, we're not going to make anyone do math. This is going to be March 31st of 2024. Now we're going to talk about carryover. If you front load the 40 hours, you can require that the employees have to use the time. So essentially you can implement a use it or lose it policy. But if the time is accrued and unused, it must be carried over into the next year. However, at no time do you have to set a cap of any more or less than 40 hours. So you may allow the employee to only have 40 hours of use per year. So something that's very interesting here is that this Act is not going to preempt any local or municipal ordinances in place right now. So in the state of Illinois, think of the Chicago and Cook County paid sick leave ordinances. So if you are following those ordinances, so if you are an employer in Chicago, or if your if your municipality has not opted out of this, your law that you're following is going to preempt the Paid Leave for All Workers Act. But if your municipality in Cook County is not following this, or you're outside of Cook County, you will have to follow the new paid sick leave law. So now we're going to move forward and talk about retaliation. So you cannot take an adverse action against an employee for using this leave, exercising their rights under the Act, or opposing practices that the employee believes are in violation of the Act, or supports the exercise of rights under the Acts. And it would be unlawful, for example, for an employer to consider the use of paid leave as a negative factor in anything like evaluating, promoting, or disciplining the employee. Now, some of you may have employees who are covered under a collective bargaining agreement. So this Act is not going to affect the validity of a collective bargaining agreement that's in effect on January 1st, 2024. However, after 2024, something to keep in mind for future negotiations is that you can waive the rights of this Act only if it's explicitly set forth in clear and unambiguous terms. Thank you. I don't know if anyone else is having seasonal allergies, but mine are out of control this year. Very appreciated. And last, we're just going to go over some employer responsibilities with you. So your usual record keeping, just got to keep track of the hours worked, the paid leave accrued and used and whatnot, what the employee has left, basic requirements. And then lastly, you're going to have to keep posted the Act's requirements somewhere in the workplace. Think of wherever else you have these posters, just put it there. And then lastly, you cannot change the employee's work days or hours to avoid providing eligible paid leave to any employee. And with that, something that Jen and I thought might be interesting is because there are no regulations right now, how the Department of Labor has provided some FAQs, so some frequently asked questions. So I thought it would be fun if Jen would pick her favorite questions and quiz me on this.
Yes, my very favorite question. So Julie, if an employer chooses the option to front load the 40 hours of paid time off under this law, and an employee leaves midway through the year, and they've used more, if they've used the PTO, can the employer require that employee to pay that time back?
Jen, that is a great question, thank you. And I wonder how many other folks were thinking that as well. No, you cannot require the employee to pay that time back. If you offer a benefit and they use it, you cannot require repayment.
What about all of our employers watching today that already have PTO policies? Is this law going to require them to add an additional 40 hours into their PTO policy, or how will that work?
Jen, that's also a great question, thank you. So by no means do you have to add an additional 40 hours to your policy. A lot of you probably already have policies that are in compliance with the Act. So what I would recommend doing is just searching through the policy, and that's also something that we would be happy to do for you, and just make sure that every aspect of your policy is otherwise in requirement, in compliance with the Act. But by no means do you have to add on an additional 40 hours. And with that, that's all Jen and I have for you today. Back to you, Eric.
Thank you, Julie. Thank you, Jennifer. Who among us doesn't have a favorite IDOL frequently asked question? Really appreciated that. And I think Julie touched on topics that are coming up a lot. I can tell you from personal experience, the volume of questions that I have received from clients with operations in multiple states related to state paid leave laws, paid time off laws, is probably the biggest category of questions that we're getting. We're seeing it in Illinois, California, New York, other places. I sit here in Wisconsin. I think it's unlikely in the near term, given the current makeup of our legislature, that we're going to see those sort of laws passed here. But many of the questions that I have been receiving are from clients who have operations in Illinois or employees in Illinois. And in many instances, these laws that Jennifer and Julie just described are going to apply to those employees, even if they're working for a Wisconsin-based employer. So important to stay up to date on that information. Illinois, in addition to some of these new paid leave laws that we've talked about, has implemented a series of additional new laws that require training in the context of sexual harassment, other types of laws that touch on sort of more what we traditionally think of as civil rights laws. We had an interesting presentation during our national seminar a couple of weeks ago, where we had one of our colleagues in California, from California, Olga Savage, give a really excellent overview of California law. But I appreciated the way that she started that presentation, because she said, I'm going to spend the next 15 or 20 minutes talking about how California law is complicated, but I want to start by telling you how much I love living in this state. And so she is a true fan of California. And I think the takeaway there was we didn't want to dissuade somebody from opening a business or doing business in a state like California, simply because there are some more challenging laws. I think we could say the same about Illinois. All of our colleagues that are presenting today are big fans of Illinois. We've got all sorts of people who are committed to the city of Chicago. In fact, there may or may not be a member of our labor and employment team that actually has a tattoo of the Chicago city flag. That's how much we love it. I'm going to make a transition to another member of our Illinois team, who are going to talk about some of those other state laws that we think are relevant. Ann Mayette, Jillian Moles, and Sarah Quinn are going to talk a bit about other Illinois employment laws, like the Genetic Information Privacy Act, sexual harassment laws, and bystander training. I am now going to turn it over to Ann, Jillian, and Sarah.
Hi, everyone. Thank you so much. My name is Ann Mayette. I'm a partner in the Chicago office. Like Eric said, we're all big fans of Illinois, and we'll demonstrate that through our presentation here today. I'll have my colleagues here introduce themselves. Sarah?
Thanks, Ann. I'm really glad Julie broke the ice about seasonal allergies, so now I don't feel as anxious about it. Yes, as Ann said, my name is Sarah Quinn, and I'm a senior associate in our Chicago office.
And my name is Julie Mold. I'm an associate in our Chicago office as well.
Right. And I think one of the biggest problems we see here in Illinois, especially Chicago potentially, is transportation. So Sarah's going to start us off with an explanation of the new requirements under the Illinois Transportation Benefits Act.
Thanks, Ann. Yes, as Ann said, we're going to get started with some Illinois changes and then transition into some information about some state laws, BIPA and GIPA, and then talk about some Chicago specifics. So to get us started today, a new change in Illinois is the Illinois Transportation Benefits Program Act. And although it says that this applies across the state, it's really just in 6 counties in Illinois. Those are counties where either the CTA, or the Chicago Transit Authority, has a transportation program, or the RTA, which stands for the Regional Transportation Authority, which includes trains that are run by Metra or the PACE transportation system. Those 6 counties, for those of you who might be sitting at home guessing, are Cook, Lake, Will, DuPage, Kane, and McHenry. So what this act requires is that beginning on January 1st of 2024, all employers must provide a pre-tax deduction for transportation benefits. Now, again, this does not mean that employers now have to provide or pay for transportation benefits, but it does mean that all employees who work for a company that employs at least 50 or more full-time employees within one of those geographical locations must be allowed to make a pre-tax deduction for their CTA or MetroCard, or for tokens or a Ventra balance that they'd like to keep. One of my favorite parts about living in the city is the CTA lines, and we were talking earlier about which lines are our favorite. And we came to a consensus that the orange is really great. You can always get to Midway, have plenty of room for your luggage, and not have to sit on the Stevenson Expressway. Anything to add?
Completely agree with you, Sarah. And you know, it's got a direct purpose. If you're on the orange line, you know where you're going, and it's probably Midway for somewhere fun.
Yes. One additional point that I'd like to piggyback on my colleague Eric's presentation earlier about this new case that came down from the 7th Circuit, the EEOC versus Charter Communication case, where Eric told us about how commuting, or rather attendance, can be an essential function at one's job. The important piece to note here is that individual had no other way to get to work besides driving. If an employer is in one of the 6 areas that we discussed a moment ago, the 6 counties in Illinois, there would be a presumption that those individuals would have an alternative besides driving. And so that's an important piece here, that this individual at issue in this case had no viable transportation alternative. And again, just to note for employers, the case came down that commuting may be something that needs to be accommodated, and that there's a series of factors that the employer would go through in the interactive process to determine if an accommodation was necessary.
Thanks, Sarah. We are going to really switch gears here and talk about some leave in Illinois. And Illinois, as Eric mentioned, keeps following the California trend, the definitely more employee-friendly trend. And Julie mentioned that Illinois recently instituted Paid Leave for All Workers Act. And so Illinois has also amended its Family Bereavement Leave Act. So it's a little more bereavement leave for employees in the state. And just as a little background, so effective January 1, 2023, Illinois expanded bereavement leave for employees who are absent due to miscarriages, unsuccessful IVF or artificial insemination, a failed adoption, a diagnosis that impacts pregnancy or fertility, and stillbirth. And this was a pretty big expansion because before this update, the Family Bereavement Leave Act, which was previously referred to as the Child Bereavement Leave Act, only provided bereavement leave for a living child if a child died. And so this really expands it and realizes that there is leave beyond a living child that people need to take. And a good way to know if an employer is is obligated to provide this leave is it's the same for any employer who is subject to the FMLA. So if you're subject to the FMLA, if an employee has been there for a year, then an Illinois employer has to provide this family bereavement leave. And so what's happening next with the bereavement leave in Illinois is they're expanding it again. And now it has different qualifications for parents who lose a child due to suicide or homicide. And the second piece we're going to talk about in my next couple slides is an expansion on VESA leave, which is family members or household members who are killed in a crime of violence. So I'm really not talking about anything super happy here. These are all unfortunate leaves, but the Illinois is recognizing that people need it beyond just a few days of funeral leave. And so this differs too. If employers are a large employer, which this act defines as if you have 250 or more employees, an employer has to provide up to 12 weeks of unpaid leave. If you're a small employer, so you have 50 to 249, you have to provide up to 6 weeks of unpaid leave. And this leave, the extended child bereavement leave, needs to be taken within 1 year of notifying your employer of the loss of your child or loss of a family member or household member. This leave is also similar to the FMLA leave in that you can take it intermittently or you can take it continuously. And for both of these bereavement leaves, something that always comes up with leaves is what kind of documentation you can require. And this extended leave effective January 1st is, it's a kind of leave that is qualified by the manner of death. And so employers there can request a certain kind of leave, a certain, cause of death document. But when you go back to bereavement leave, when you're looking at taking leave for a stillbirth or an adoption, employers can't require documentation of what reason the employee is taking the leave, because that kind of gets into things we're going to talk about, get into medical, their privacy. And so employers want to stay away from anything, specifying the reason of the employee's leave. But if it's qualified as to if you lose a child due to suicide or homicide, you can request documentation of that manner of death. And so this is the piece we were going to talk about. That second additional leave that Illinois is enacting is really an expansion to VESA, which is the Victims Economic and Security and Safety Act. So a refresher for that is this is an Illinois law that allows employees to take leave when they need to seek medical attention or counseling services, services from a victim services organization, to obtain legal assistance, or to participate in safety planning. And this really is to protect victims of domestic violence or any kind of crime of violence. Again, going back to similarities to FMLA, employers have to offer up to 12 work weeks, 4 to 12 work weeks in any 12-month period. And so the expansion here is that employees can also now take leave, specific kinds of leave, if the family member or household member's death arises from a crime of violence. And so now employees can take leave to attend the funeral or whatever funeral alternative the family has, to make arrangements following a death after crime of violence, or to grieve the family member. Employees can take up to 2 work weeks here for this additional leave that will be added of unpaid leave. And this leave needs to be taken within 60 days after the employee receives notice of the death of the victim. So all of these kind of leaves are a little interrelated. They're, tough times, but they all have little different nuances. And this is another kind of leave where employees can take, or employers can ask for a certain kind of document, stating the, again, cause of death. And so I'm going to switch gears here a little bit, but definitely not a happier note. And this is it's a little different because the Illinois Gender Violence Act has been around for a while. And it's an act separate from, our typical employment laws, where it allows an individual who is a victim of gender-related violence to sue the perpetrator of the violence and seek damages. And Illinois has essentially created a new cause of action that people can bring against employers. And this is now stating that employers can face liability if one of their employees or agents is liable for the gender-related violence. It committed the gender-related violence. So now someone can sue, not only the person that committed, but their employer as well. And so this can happen when an employee is directly performing the employee's job duties, and that's when the gender-related violence occurs, or when the agent of the employee is involved in the performance of work, and that's when the gender-related violence occurs. And so here are some important steps to protect yourself, your company from liability, because these are the things that a court would need to find in order to hold the employer liable. So the court would need to find that the employer acted in a manner inconsistent with how a reasonable person would act under similar circumstances. So that's kind of, a different standard. But so if you look at it for an employer, you would have to act as the employer would reasonably act. Also, you would have to fail to supervise, train, and investigate complaints. And sexual harassment training, which I know we all do, is an affirmative defense that can really help employers in this category.
All right, so I would love to say that we're going to move on to a less depressing topic, but I don't think we are. Sarah and I are going to talk about everyone's favorite topic in Illinois, BIPA and its new counterpart, the Genetic Information Privacy Act, which is mirroring a lot of BIPA-related claims, an increased number of class actions. So I'll let Sarah get started with the recent updates to BIPA.
Last year, you may recall that we talked to you about the first of its kind trial for the Biometric Information Protection Act, Privacy Act, excuse me. In that trial, $228 million was awarded to the plaintiffs. That verdict has been vacated, or was previously vacated, by Judge Kennelly in the Northern District of Illinois. Next slide, Anna, if you will. Here's how we got to $228 million. The jury found that there were 45,600 violations of the act, and that each of them was an intentional violation. So Judge Kennelly multiplied those two numbers together and got $228 million. However, 4 months after that verdict came in, the Illinois Supreme Court made two very clear rulings that have impacted BIPA in a big way. One, that every single scan of someone's fingerprint or iris is an independent violation of the act. And two, that damages are discretionary. That means that intentional violations don't necessarily equate to a $5,000 statutory penalty. So the verdict was vacated so that a new jury could decide how much each of those violations were worth. And hot off the presses, within the last few days, Judge Kennelly entered an order saying that the two sides had materially entered into a term sheet for settlement. So if you'd like to hear how this one ends, you'll have to tune in next year.
All right, thank you, Sarah. So next we're going to talk about the Illinois Genetic Information Privacy Act. This act is somewhat similar to the way BIPA acts in kind of the format of how you see it go through the courts, but differentiates itself in what it actually covers. So it was enacted in 1998 as a means to protect information about an individual's genetic material. And so the act is largely based on the Federal Genetic Information Non-Discrimination Act. And so many of the terms and conditions that are in this act mirror that act. And we also have terms and conditions that come out of the privacy sections of HIPAA. So under the Genetic Information Privacy Act, genetic material is defined broadly as not only the results of genetic tests, but also genetic tests of family members and the manifestation of disease or disorder of a family member of the individual. So, the question here is, okay, how are we seeing this related to employers? So we have seen a significant uptick of class actions filed in Illinois under this act related to employers who conduct pre-employment physicals where they are gathering family member medical history. So we are seeing lawsuits from these plaintiffs where they're saying we sat down for our pre-employment physical, they collected our family medical history, and therefore that's a violation of the act. These are on a huge uptick. We don't have a lot of information on how these are going to proceed through the courts because it's so new, but we can take some guidance from GINA cases that have moved through the federal courts. So basically what the law is saying that employers can and cannot do is use any information from genetic testing or information derived from it that can be used in a negative way related to a condition of employment. So hiring, firing, things like that is what the act is preventing employers from using that genetic information. It's also related to workplace wellness programs. Normally, if you were to read the act, you would look at it and say, okay, I don't know that I can continue doing a workplace wellness program. The act does provide some exceptions so that employers can continue to offer that benefit for employees. If an employer wishes to implement the workplace wellness program, they're barred from using genetic testing or information unless the employer offers health or genetic services, the employee provides written authorization, and then the information that is provided is only provided to the employee or the family member. And if the information is provided to the employer, any individually identifiable information is used for the purposes of those services and not disclosed otherwise. So this is going to start working its way through the courts. We're going to keep following it. But the moral of the story is to take a look at your pre-employment physicals and testing for employees and determine if there are ways that you can mitigate risk by not collecting that family medical history. So we're going to transition a little bit from Illinois in general to more Chicago specific. But some of this does really mimic a lot of the laws that we'll see that you have seen already in Illinois. Specifically, Chicago has, as of February 1st, 2023, amended the Chicago Human Rights Ordinance to prohibit employers from discriminating or taking retaliatory action against applicants or employees based on decisions relating to their reproductive health or gender affirming care. And so really the act is preventing employers from taking that into account with respect to any terms and conditions of employment. Also, discriminating or taking action or requiring applicants to sign waivers purporting to deny the right to make their own decisions on reproductive health care or gender affirming rights. And so this is Chicago specific. It's under the Chicago Human Rights Ordinance. And so that means that any violations would be under the Chicago Commission on Human Rights, which is a very little known agency within the city that I don't know that a lot of people even know exist. It mimics acts kind of like EEOC, Illinois Department of Human Rights. And so any claims for violations of this Chicago Human Rights Ordinance would be before that agency, and it provides for damages in the amount of either $500 or $1,000 per offense.
Another change quickly for Chicago-based employers is the Fair Work Week Ordinance. It's been updated to allow employees 14 days of notice of their schedule. This is up from 10 days. So it's important, if you are an employer in the city of Chicago, to take a look at these bullets here about what it means to be a covered employer. All of those criteria must be met for you to be under the purview of this law. So the biggest change here is the change from 10 days to 14 days. Here on this next slide, you can see the penalties for not providing that advance notice, which equates to additional pay that the employees would be entitled to if you, the employer, changes the schedule. And the last thing important to note here is there is something called the right to rest that's in this ordinance, which allows an employee to turn down a shift if you don't give them enough space in between the end of one shift and the start of another.
Thank you, Sarah. And for our last Chicago-specific update that we have here is expanded criminal history screening. I think a lot of you who have followed the changes in Illinois are also going to think this is very familiar. So it was effective as of April 24th, 2023, and Chicago's amended its Ban the Box ordinance to require employers with a Chicago business license or who maintain a facility in Chicago to provide the pre and post adverse action letters or notices when they take an adverse action related to criminal history for an employee in their employment screening. And so, like I said, this largely mirrors the Illinois law that was enacted. The differences are here. The Chicago ordinance also applies to employers with 15 employees and includes steeper penalties than you will see under the Illinois Act. So like the Illinois Act, you have to provide the pre and post adverse action letters and go through that individualized assessment that is required under the Illinois law. And so you have to determine if the criminal offense that was found on the background check for the employee was individual, if that has a effect on the actual job that the employee is going to have with your company. So you have to make that individualized assessment as to whether there's a substantial relationship between the two. And the other part of that is also if there's a criminal offense that comes up on the background check, whether or not there is a substantial risk of harm from that employee to the other employees in the organization. And so when you're going through that individualized assessment, there are a series of different mitigating factors that the law requires you to follow, much like the Illinois law, the length of time of the conviction, the number of convictions, the nature and severity of the conviction, any evidence of rehabilitation efforts, among many, among other, things that you need to look at for potential mitigation efforts. So with that, I think we have wrapped up our summary of the many changes that we have seen in Illinois and Chicago. I think, Eric had mentioned California and, the many laws that are, maybe a little more employee friendly there. I think Illinois is on that track, as we've kind of seen here, and we can definitely expect more to come. And with that, I'll turn it back over to Eric.
Thank you, Ann. Thank you, Jillian. Thank you, Sarah. Really appreciate that overview. We're nearing the end of our journey here. I love the love fest that we've kind of got going on for public transportation. I made reference to the Amtrak Hiawatha. We've talked about our favorite CTA lines already. So why don't we get on that train in Union Station and head east to Michigan. You could get on the Pere Marquette. That's going to take you to Grand Rapids. You could take the Blue Water, which is going to take you to East Lansing and Port Huron, or maybe the Wolverine, which will take you all the way to Ann Arbor or Detroit. And what you're going to find there is our two excellent labor and employment attorneys in Michigan, Tom Setos and Zoe Mayhew. And Tom and Zoe are going to give you a quick overview of some recent changes to Michigan law that we think are relevant for employers. So Tom and Zoe, please take it away from Michigan.
Thanks so much, Eric. We are delighted to be here with you, speaking to you from Michigan. My name is Zoe Mayhew, and I am a labor and employment attorney, and I focus my practice more on the advice and counseling side, trying to prevent issues before they even happen.
And my name's Tom Setos. I'm a labor and employment litigator in Michigan.
So we have several really exciting topics for you today. We're really focusing on just some high-level Michigan updates to the law. We are going to talk about the newest Crown law that has been implemented. We are also going to look at the repeal of the right-to-work statute here in Michigan that is going to have far-ranging consequences for unionized employers. And then we're going to talk about a controversial topic, our Paid Medical Leave Act and minimum wage and tip wage statutes that have undergone major procedural updates throughout the year. And we're just going to let you know the status of those laws and what may be coming. So the Crown Act in Michigan was signed into law in June 2023 by Governor Whitmer. And it is following on the heels of several other states. We're actually the 23rd state to sign a Crown Act law into an effect. And what our Crown Act does is it expands our Elliott Larson civil rights Act, and it expands the category of race. So let me talk to you a little bit about that background, and then we'll go into exactly what Crown Acts and Crown Acts, particularly in Michigan, protect. So under the Elliott-Larsen Act, the covered employer is anyone with one or more employees. So that is going to be everybody out there, right? Civil rights are widely protected, and our statute was designed to protect all employees, amongst other categories as well. And currently, prior to June, the Elliott-Larsen Civil Rights Act was designed to protect race as a protected category. Obviously, federal law and state laws across the board protect race. But what they didn't do is they didn't address natural hairstyles that are traditionally associated with particular races. And we had a history whereby employers were requiring employees to cut dreadlocks. They were making implications that braids were too casual for the workplace. There was both overt and microaggressions towards natural hairstyles. So Crown Acts have been enacted across the country. There was an attempt to enact a federal Crown Act that did not pass. But they are really designed to specify that race protections include hairstyles. In Michigan, it's not something new to us. We've had local ordinances that protected them, but what Governor Whitmer signed has now made it a statewide protection. So the implication for human resources and employers is to understand that while you may have an anti-discrimination and harassment policy, that policy should both on its face and in its writing be expanded to include natural hairstyles. It includes hair texture, afro hairstyles, protected hairstyles. So things like braids, locks, twists, head wraps, all of these things really should be addressed, and they should be spelled out to employees that they're protected. They should be part of your anti-discrimination and anti-harassment training so that other employees aren't making insensitive or racist, overtly racist comments about them. But it's basically just an additional clarification, much like we saw. And then the most recent bill that passed, Tom is going to walk you through.
So in Michigan, following up on the Crown Act, we've also had Senate Bill 4, which passed. It amended the Elliott-Larsen Civil Rights Act to include sexual orientation and gender identity or expression as protected classes. This follows very much in line with the changes we've seen at the federal level. And then in May, we also saw Senate Bill 147 pass, which amended the Elliott-Larsen Civil Rights Act to include all pregnancy terminations as protected medical conditions. Those two changes really affected the Elliott-Larsen Civil Rights Act, but one of the largest changes that happened in Michigan this year is the passage of Senate Bill 34. On Friday, March 24th, 2023, Michigan became the first state in nearly 6 decades to repeal its right-to-work statute. We've seen several changes at the federal level of labor and employment law, which largely follows the changes we've seen in the executive branch. The one thing about labor law is it's a pendulum that consistently changes when a new party is elected into office. Michigan's repeal takes effect March of next year and has a significant impact on employees, employers, and is going to really bolster labor union practices throughout Michigan. Employers that bargain union security clauses out of their contracts following the passage of the Right to Work statute in 2012 can expect unions to once again try and reinstate those within collective bargaining agreement. Employers that bargain language that simply suspends union security clauses while the Right to Work statute was passed, they can expect the union to start enforcing the union security clauses immediately. So what is a right to work state? Starting about 6 decades ago, we started seeing unions or employers want to take away some of the power that unions have over employees. And a lot of employees were also looking for this protection. So Section 14B of the NLRA protects the rights for states to negate union security clauses by enacting right to work statutes. Not counting Michigan, 26 U.S. states have these statutes. Right to work statutes again, prohibit unions from enforcing union security clauses. So union security clauses are clauses that require employees to pay union dues. So this allows employees in right-to-work states to decline or resign from union membership and avoid paying these dues. They would still have the union negotiating and bargaining on their behalf, but they're not paying union dues to the union. Right-to-work states protect free choice and force unions to offer services that employees consider worth the cost of union dues. Labor unions were frustrated by this because they felt that many employees were freeloading off their collective bargaining services, while many other employees, another set of employees, found that this really forced unions to put a lot of effort into bargaining for what they actually considered important. Under the new law, employers in unionized workplaces will no longer have a statutory right to opt out of union membership or refrain from paying union dues or fees as a condition of employment. Meaning if you're an employee that is part of a union and has not wanted to pay union dues or have not been paying union dues for the last several years, you will now be required to pay union dues to keep your job. In essence, this legalized union security claims and collective bargaining agreements that it forces employees to pay dues, fees, assessments, or expenses. Essentially, you now have to support the union. And it permits unions to force employers to fire you if you fire those employees who refuse to do so. It also removes the financial penalty for using force, intimidation, or threats to compel employees to join or not join a union. Michigan's legislature also took measures to prevent enactment of other right-to-work protections in this bill. For example, they inserted language into the bill that prohibits any state municipality from passing any local or state ordinance that prohibits union security clauses. And now back to you, Eric.
Thanks, Tom. Appreciate it. We got one last poll question here for the audience. We thought it would be fun now that you've heard about Illinois, Wisconsin, and Michigan. If you were starting a new business today and you could pick your location, which state would you choose? Would you choose Wisconsin, where we have a new Supreme Court that's going to throw employment laws into flux? Would you choose Illinois and have to do all that crazy math with the new paid leave laws? Or would you pick Michigan, where there's a lot of significant changes as well? So go ahead and pick one of those, A, B, and C. I think it'll be kind of fun for us to see. And maybe there's a little homerism here too. Why don't we click through and see what people have selected? Wisconsin, that's the #1 pick. I don't know how much of that is because of the business climate that we have right here in the state or the percentage of population made up as our group here that are attending today. But I just think that that's kind of an interesting result. All right, let's go back to Tom and Zoe for a final portion on some updates to Michigan law before we close out today. Thanks for sticking with us.
All right. Thanks so much, Eric. It is always very interesting to see where everybody comes out with these polls. I love it. Right now, I'm going to talk a little bit about the current Paid Medical Leave Act, and then Tom is going to tell you the whole kerfuffle of this summer and where things have landed in terms of what do we need to comply with and what changes could be coming. So the Michigan Paid Medical Leave Act was enacted in 2019, and one of the big changes was it only applies to employers of 50 or more employers. So many people on this call, this act would have no effect. If we are looking at the change that's coming that Tom, or that could have been coming that Tom will talk about, it would have applied to 10 or more employers of 10 or more people. So major changes. It really only applies to non-exempt employees. So there are a lot of exceptions. I believe there's 12 exceptions in the statute, but the biggest one is it's not going to apply to our exempt employees, and it's not going to apply to our part-time employees who are averaging 25 hours or less per week. So the Paid Medical Leave Act is basically a sick leave law. Lots and lots of states have them. Michigan was simply following suit in this growing trend. And what it did is it provided very specific protections for both their employees and their immediate families. That's defined in the statute. But it applied to physical or mental illness, injury. It applied to diagnosis and care, preventative care. It was updated to include COVID things such as closure of primary workplaces, cares for children whose schools have been closed, exposure to communicable diseases. It really was a new right because up until then, Michigan didn't have required vacation or required sick time. So it was a big change. And in order to get this big change passed, what was initially on the ballot initiative and what was eventually passed were two very different things. It got watered down quite a bit. The other aspect that the PMLA covers is domestic violence and sexual assault situations. So it was new rights for employees. It rolled out in 2019. There was a presumption of compliance for employers who already had vacation or PTO policies that offered 40 or more hours, so long as they offered them in these precise situations. Some tweaks had to happen. We're not going to go through all of them right now. But for example, if you used an accrual system, then you had to allow carryover of a certain amount of time. But you didn't have to allow, or you don't have to allow, use of more time. So some weird administrative things that were happening there. As opposed to if you front loaded it, then you did not have to do the carryover. So a lot of employers were able to work with their current existing policies, but employers who didn't have paid time off did have to create a new paid medical leave policy or an all-encompassing PTO policy that provided leave for these reasons. It was a very, very big change when it came out. It took employers time to get into compliance, but again, this presumption of compliance, if there was already a generous vacation policy, was quite helpful. And just when employers were getting used to it, got our policies updated, and everybody was ready to go, things changed dramatically. And Michigan really started freaking out that we were going to have to rewrite our policies, that employers who were not affected were now going to be affected, and that we were going to have to give way more leave than we originally thought.
Yes, there was substantial uncertainty as to what laws we needed to follow. And this goes all the way back to the initial and original ballot proposals. So in 2018, Michigan's One Fair Wage circulated petitions to have voters consider a proposal to increase the minimum wage to $12 an hour by 2022. And it was $9.25 at the time. And it essentially was tying this new minimum wage to the rate of inflation. Lawmakers utilized and adopted an amend strategy to both adopt their own versions of Michigan's One Fair Wage Act and of the sick leave law that was proposed at the time. And so when they adopted and amended these provisions, they watered them down to reduce the burden on employers that was originally proposed. In July of last year, we saw a judge of the Court of Claims throw out the changes made by lawmakers and deemed them to be unconstitutional. Then there was a stay issued for a temporary period of time to allow for employers to change their policies and enact the original ballot proposals. During this time, this was immediately appealed.
And Tom, at that time, many of you on this call were calling us scrambling, trying to update your policies and get ready for this change. And our guidance across the board was?
Do nothing. It was a wait and see approach that we had to take to see what was going to happen with the appeal that was filed.
And in hindsight, the do nothing approach was the right approach.
And so it's important to take a look at the differences of, for example, in the Improved Workforce Opportunity Act, that was the ballot proposal related to a minimum wage, and then under the Earned Sick Time Act, which was the ballot proposal related to sick leave. Under the original ballot proposals, employers who employed 10 or more employees, no longer 50 or more employees, who must provide 72 hours of earned paid sick time per year to employees who work at least 20 calendar work weeks in a year. So quite a bit more leave and affecting far more employers. Also, employers who employed less than 10 employees were required to provide 40 hours of paid earned sick time and 32 hours of unpaid leave. And all employers had to allow employees to accrue earned sick time at the rate of 1 hour for every 30 hours worked. Under the initial Improved Workforce Opportunity Act, the non-tipped minimum wage was going to increase to $13.03 per hour for 2023. minimum wage increase was then going to be adjusted to the consumer price index each year beginning in 2023. And the minimum wage for tipped employees would be increased to 90% of the minimum wage in 2023.
This was a huge change for the restaurant business, which is obviously a big part of who would have been lobbying against these changes, because as we know, tipped workers make substantially less, and we're able to circumvent that, their employers are, because of the tips. So increasing to 90% would have been a huge impact on that industry.
They essentially wanted to phase out the tip credit rules that many restaurants rely on. Then in January of this year, the Court of Appeals overturned that order. And that decision took immediate effect, which once again reinstated employers to what their current practices were. The Michigan Supreme Court has now granted the Mothering Justice's application for leave to appeal the decision. And so now the Supreme Court is reviewing it, and a decision is expected soon as to what law we're going to have to follow.
The main takeaway, though, as we said back this past winter, is do nothing right now. Right now, it is a wait and see approach. There are no changes. All you need to do is make sure that you're in compliance with the current PWMA and the current minimum wage requirements in Michigan. That was a lot of updates in a very short amount of time. Obviously, if you have any questions, our team is here to answer. And Eric, thanks so much for having us. Signing off here from Michigan.
Thank you, Zoe. Thanks again to both Tom and Zoe for that excellent presentation. We're really lucky to have them part of our team. Really excited to have all of our attendees from Michigan and excited to be able to support you guys across our platform here. Appreciate you all for sticking with us. We hope the information that we shared today was helpful for you and your organization. As a final reminder, this program has been approved from HR and continuing legal education hours. You can report those hours through the platform here by clicking on the CEU icon at the bottom of the screen. You will get a certificate of attendance with course numbers and a recording of this webcast tomorrow. And we would really appreciate it if you could complete our short survey. We use that information to plan our future presentations. Thank you. Have a great day, and we look forward to seeing you again soon.